Welcome to John Redmann, Power of Attorney, the show that aims to empower you through the knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Well, part of the foundation of our judicial system is the appellate process, the freedom to appeal a court decision and possibly move a case to a higher court. But the appellate process is largely mysterious to the general public. Our guest today will definitely shed some light on how the process works. We are happy to welcome to our show today Judge Terri F. Love of Louisiana's 4th Circuit Court of Appeal to the Power of Attorney.
When and how are cases appealed? How do judges from the appeals and Supreme Courts look at cases? Judge Love will answer these questions and many more in this first part of our two-part series on the appellate courts.
But before we bring Judge Love on, John, tell us about your experience in going through the appeals process, because you have a lot of experience with this. Yeah,
well, you know, I've been doing this 20-something years, and very often we are forced to go to the Court of Appeals when the other side appeals, or if we don't get the outcome we'd like at the trial court level, we go to the courts of appeal to try and make things better. Sometimes on our way to the trial before a case is resolved, or if it's not resolved going to trial, we do what's called interlocutory appeals. That's where a writ has to be taken because we don't like a decision the judge makes on the way to trial about letting somebody out of the case or about trying to get information. So today's a good day to learn the basics of history, and next show the history of the courts, and the next episode more details.
That's right, because we're going to have two parts.
I'm excited about this.
There's so much to learn about the Court of Appeals. Interlocutory. That's a new word for me. It'll be a new word for you, but there's lots to learn about that word.
Lots to learn.
So stay with us, because coming up next, Judge Terri Love will join us here on the show. Stay tuned. We'll be right back. Hello, everyone. Welcome back to Power of Attorney. Well, if you ever find yourself in a situation where you need to appeal a court ruling, there are some important things that you really need to know as you begin that process. And today we're excited to welcome the Honorable Terri F. Love to Power of Attorney. She's going to give us a crash course, if you will, on the appeals process.
Judge Terri F. Love sits on the appeals court for the Louisiana 4th Circuit, a position she's held since 2000. And before that, she was Chief Deputy City Attorney, and before that, or maybe before going on the Court of Appeals, she was a district court judge. Judge Love, thank you so much for joining us today, and we're looking forward to having this discussion with you. So
well, thank you. It's a pleasure to be here, and it is a pleasure to also speak about a subject that I'm passionate about,
right.
The appellate process. There are not many people who are passionate about the appellate process.
But there are lots of people who have to use the appellate process.
Yes, we are a court that is very open to the public, and we are always interested in getting the public a clear understanding of the nature of our work, because a lot of people are not familiar with the work of the appellate court.
Well, before we plunge into the appeals process, why don't you give us a background, a little bit of history, a little bit of background of the appellate
The appellate process, especially in the states, is parallel to the federal system. And for many years, there were only trial courts. And in many cases, when they decided they wanted an appeal, the trial court judge would be the appellate judge. So the judge would be reviewing his own decisions. So I think Congress decided in 1891 that that wasn't a good idea. So the appellate process was created, and many states have followed that basis in creating an appellate process. The state of Louisiana, we have the trial courts, we have my court, which is the intermediate appellate court, and then we have the Supreme Court, the court of last resort. And the judges on that court are not even referred to as judges. They are justices. The judges on the trial court and the appellate court are judges.
Okay.
And one of the things that I find that is very beneficial with the appellate process is that you sit in panels of 3, 5, or possibly 12. And that was a big transition for me personally, coming from the trial court, where you were the person who made the decision. Now it becomes a majority rule process. And when you first arrive on the appellate court, having been a trial court judge, that is an adjustment. But what you learn in the process is that that's better for the public, because there are more people reviewing it. I, as a judge, don't make the final call on the appellate process. There has to be 2, and in some cases, 3 judges who agree.
What determines the size of the panel?
The size of the panel is determined by the Constitution.
Okay.
If for any reason a case will be reversing the trial court, there must be 3 judges who agree. So if 2 judges agree and the 3rd doesn't, then the case becomes a 5-judge case.
Oh, okay.
And then 5 judges will make a call, and you will need 3.
And so we're clear. Is that the same rule if it's a appeal of a civil case or a criminal case?
No, it's only in civil cases. Criminal cases, it does not apply.
Okay.
And then there are some cases, political challenges, that we hear in panels of 12.
Really?
Some cases with 5. So it's set out by the Constitution, which guides us, and then some cases are set out by local rules of that particular circuit. The history of the appellate process, and there's something about appeals that I think people just get somewhat confused, and the difference is I don't issue a judgment as an appellate court judge. I issue an opinion.
Okay.
A trial judge issues a judgment. An appellate court issues an opinion.
And so for the general public, what is the difference between a judgment and an opinion?
A judgment is binding on those 2 parties. The opinion sets precedential value. So once I issue an opinion, it can be used as guidance in other cases, whereas a trial court judgment is only impactful upon upon the parties involved in that case.
And that's really important for people to understand, and something that maybe you were getting ready to explain. You're an appellate judge for the Louisiana 4th Circuit. That covers a certain geographical area. So your opinions have precedential value. They can be treated as law to help other people facing litigation covering a certain area. But there are a lot of circuits.
There are 5 circuits in our state, and the 4th Circuit covers Plaquemine, St. Bernard, and Orleans.
Right.
Until 1981, Jefferson Parish was included, and I think in 81 the circuits was split and you created the 5th Circuit.
Okay.
Right.
So we're one, I can say from my travels and interaction with other appellate judges around the country, many states have only 1 court of intermediate appeal. But we have 5 circuits here in our state.
So that makes us pretty unique, right?
Yeah, it does in some circuits. Some states have more, but we are one unique situation.
But so the opinions that you issue for your court, do those opinions hold for other courts here in the state?
They can have persuasive authority for others, but it's controlling in our circuit.
Okay.
And that's where the Supreme Court comes in. If there are conflicts amongst the circuit, then the Supreme Court must make an ultimate decision to decide what is the law of this state.
Right, and we learned that in law school, persuasive authority versus controlling authority. So if your court makes a decision that says in all situations where A, B, and C exist, then the judge must decide a case this way. If someone's in another circuit, let's say they live in St. Tammany, which is not within your geographical region, it's persuasive to somebody in St. Tammany. But if the Court of Appeal, which covers St. Tammany, I think that's the 1st Circuit, I think so, then that court in the 1st Circuit may have its own ruling, which might be the same as yours, might be different. But the Court of Appeal for St. Tammany, when they make a decision, the trial judges in St. Tammany are bound by what the Court of Appeal in St. Tammany does.
And remember, we're under the code, so we're basically interpreting the civil code, which makes Louisiana totally different from any other state.
The Napoleonic Code, as we were taught.
Mr. Napoleon's code. And the appeal courts, I think that there's some things about the process that a lot of times I interact with attorneys who do not understand. When you have an appeal before our court and you argue before a panel or 3 or 5, you don't know who is the writer on that opinion. And there's a reason for that. We don't want you to come in court and focus all of your energy on one judge.
Just arguing to one judge, because you don't know who's going to be the
you don't
chief
know
author
who's
of
going
the
to be the
decision.
chief author, and that is confidential. And in certain cases, that can change. If the chief author proposes an opinion and everyone does not agree and there are dissents, that chief writer could then become the dissenter, no longer the writer of the opinion. So we don't want you to come in court and focus all of your energy on one person that might not be the writer. And I think we want everyone who's sitting there to be treated the same by the litigants. So you'll feel that this is a one vote.
And how is that determined? Is that something that you can share? How is it determined who'll be the author of that opinion?
The computer.
Oh, okay. Okay. So you all have no say in that. That is generated by the computer.
And it's a random decision.
Random decision by the computer.
Okay.
And that makes it great. When I receive my docket every month, I look at it and I say, okay, this is my case. Then sometimes you'll get them and you'll say, oh, this is interesting. I wish I was writing this case, but it's not assigned to you. So it is computer generated.
Interesting.
And I think another thing about the process that a lot of people don't understand is that we're not there to say point blank the trial court was wrong. We're guided by a standard of review. And sometimes it's abuse of discretion, manifest error, and sometimes it's a de novo review. That means we review the record in its entirety. And we always review the record.
Well, that's something that you mentioned when we were talking earlier. It's all about what's in the record.
If it's not in the record, it doesn't exist for me. I am bound by the record, and the record consists of transcripts, what occurred in court.
What the court reporter typed and took down the evidence from the witness stand and exhibits that were entered at trial, correct?
And all of the pleadings that have been filed by the parties. That's what we are bound to.
So it's not retrying the case.
No.
It's not bringing in new evidence and all of that.
You definitely cannot bring in new evidence.
Okay.
We are bound by that because think about what that would do to the process. We would be retrying. That would never, one of the things you want with the legal process is you want things to be final. That's what makes our system work, if there's something that's final and that you understand. So if we were constantly allowing new evidence in, the process would never be final.
It'd be like the trial never ended.
And one of the things I think that's very important for me as an appellate court and having been a trial court judge is understanding the discretion that's given to the trial court judge. Because when I read the record, I'm just reading the black and white record. The assumption is that when the trial judge hears the case, he gets that opportunity to see the demeanor, the position the witness takes. And you and I know everything is not what you read.
Right.
It's what the trial judge can read into that witness's demeanor or any action that's taken by the attorney.
You're laying eyes on the witness and listening to the tone of their voice and making a determination about their credibility, which is hard to get off the words on the page.
And that's why once the trial judge makes a credibility finding, it is very hard for the appellate court to reverse that. Because the trial judge has been there. And many trial judges know the code word, I find that this witness is not credible.
Right.
And once the trial judge makes that finding and says why, then it's really going to be hard for the appellate court to reverse on that basis.
And the courts have to give that great weight under the law.
Great deference to the trial court judge. So having been a trial court judge, when I first arrived at the appellate court, and it's something that all judges work on, I cannot say, if I were here, I would have done this.
I see.
That's not the test.
Yeah, and so when you look at the number of cases that are upheld at the appellate level versus those that are overturned, it's very interesting, and I want you to hold that thought because we're going to get to that as soon as we come back from the break. Coming up next, Judge Terri Love helps us answer your questions, so stay tuned. We'll be right back. This is great. I'm learning so much.